Court, New Jersey is now in session. The Honorable Edward M. Coleman presiding.
Thank you. Be seated.
This is the return date of our motion to compel discovery about an incident of racial bias directed against Jayson Williams by a superior officer of the Hunterdon County Prosecutor's Office who was involved in the investigation and handled evidence during the trial. But apparently there was a meeting in the office of the Hunterdon County Prosecutor's Office during the investigation, perhaps with discussions about the investigation, and a superior officer uttered a racial epithet towards Jayson Williams. As the state tries to say in its motions or its reply brief, there's no way this evidence could have been used, misunderstands the dynamics of this trial. Judge, you were a prosecutor. Most of us at this table have been prosecutors. This evidence could have been used, and we all know this evidence should have been turned over 5 years ago.
This material is completely immaterial to any issue pertinent to the defendant's guilt at the anticipated retrial for aggravated manslaughter. Why is this so? Well, to begin with, and most importantly, this individual was never called as a witness at the first trial. Well, there's a reason for this. He had no direct knowledge of the case, and he had no involvement with the handling of the physical evidence in the case prior to trial. Now, there is a tremendous amount of evidence, including defendant's post-conduct activity, which goes to the issue of recklessness. And I can understand, frankly, in light of this evidence, why Mr. Hayden, and he was rather, I think, candid about this, wishes to interject the issue of race into this case directly. But unfortunately for the defense, this individual is not the Hunterdon County equivalent of Mark Furman. Mr. Furman handled the key evidence in the O.J. Simpson case. He was a lead investigator. He was a key witness in that case. Conversely, and in marked contrast, this individual, while at the time employed by the prosecutor's office, had no pertinent knowledge of the information.
Your Honor, just very briefly, again, the state tries to laud itself and pat itself on the back because it made a timely disclosure, timely 5 years late. We didn't introduce race to this case. The superior officer 5 years ago who uttered an ethnic slur against Mr. Williams introduced race into this case, and we're entitled to know what happened, and we're entitled to cross-examine on it.
But as we know, or we now find out, some material apparently was not disclosed, and we need to investigate what happened. As we know, the defendant has previously gone to trial with regard to these issues and has been found guilty of some counts and not guilty of some counts, and we have a reckless manslaughter charge still remaining that has to be resolved. State's contending that the misconduct of the former employee is not relevant to any of the issues used to determine the defendant's guilt. Although the defense claims that this required discovery under Gigolo, the state points out that this information could not have been used to impeach for impeachment purposes because this superior officer was not a witness in the first trial and will not be a witness in the second trial, and notes that the officer's involvement in the case was peripheral. Officer had no contact with any of the physical evidence, as I understand the argument. In effect, the court is granting, in part, the defense application for an in-camera review of the entire file so that we can make disclosure as to those parts that are appropriate.